If you're a green card holder living in the United States right now, and you have been feeling uncertain, anxious, or confused about what the new immigration laws actually mean for you, you are not alone, and this video was made specifically for you. In the next several minutes, we are going to walk through exactly what is happening, what has changed, who is most affected, and what every green card holder needs to understand right now to protect their status and their future in this country. This is not about panic, this is about being informed, and in immigration, being informed is the most powerful protection you have. So let us begin. The United States has seen a significant wave of immigration policy shifts over the past several months. Executive actions, new enforcement directives, and updated USCIS processing guidelines have created a landscape that looks and feels very different from what many green card holders were used to just 1 or 2 years ago. And while much of the public conversation has focused on undocumented immigrants and border enforcement, the reality is that lawful permanent residents, people who have gone through the legal process, waited years, paid fees, passed background checks, and received their green cards, are now also navigating a more complex and more carefully scrutinized environment than before. That is the core of what we need to talk about today. A green card, officially known as a lawful permanent resident card, gives you the legal right to live and work permanently in the United States. It is one of the most valuable immigration documents in the world. But what many green card holders do not fully realize is that a green card is not unconditional, it is not citizenship, and under certain circumstances, it can be revoked, challenged, or placed under legal review. This has always been true in US immigration law, but the current enforcement environment means that conditions and behaviors that previously went unnoticed or were rarely acted upon are now being examined with a much higher level of scrutiny. Let us talk about what has specifically changed and why it matters. One of the most significant shifts involves the expanded grounds for enforcement action against lawful permanent residents. Under updated enforcement priorities, both USCIS and the Department of Homeland Security have made clear that any green card holder with a criminal record, even a minor one, even an old one, may be subject to renewed review of their immigration status. This is not limited to serious felonies. Immigration law has always contained provisions that make certain criminal convictions grounds for removal or status review. But the current enforcement climate means that cases that might have been deprioritized in previous years are now being actively pursued. This is one of the most commonly misunderstood areas of green card law. Many permanent residents believe that once they have their green card, a past conviction that was resolved years ago no longer affects their immigration status. That belief, while understandable, is not entirely accurate. Certain categories of criminal offenses, including some misdemeanors, drug-related offenses, crimes involving moral turpitude, and domestic-related violations, remain grounds for deportation proceedings regardless of how much time has passed. If you or someone you know has any criminal history, no matter how minor it may seem, the single most important step right now is to consult with a qualified immigration attorney who can assess whether that history creates any current exposure under the updated enforcement priorities. Now let us talk about something that has been generating a great deal of anxiety in immigrant communities, and that is the increased scrutiny that green card holders are now experiencing at US ports of entry when returning from international travel. Under established US law, green card holders have the right to return to the United States after traveling abroad. This right is well established and protected. However, it is not absolute, and the current enforcement environment has introduced a level of inspection and questioning at airports and border crossings that many returning residents have found surprising and stressful. Customs and border protection officers have broad authority to inspect travelers, ask questions about their travel history, examine electronic devices, and conduct secondary screening. In recent months, there have been documented reports of green card holders being subjected to extended questioning upon return to the United States, in some cases lasting several hours. Understanding why this happens is important. CBP officers are tasked with verifying that a returning resident still meets the legal requirements for admission. If a green card holder has been outside the United States for an extended period, has a criminal record, has not filed US taxes or triggers any other review criteria that can result in additional questioning or secondary inspection. This does not mean your green card is automatically in danger, but it does mean that preparation matters enormously. Knowing your rights, knowing what to carry with you, and understanding how to respond appropriately during CBP questioning can make a significant difference in how your re-entry experience unfolds. There is also a specific issue that we want to address clearly here because it creates confusion for many permanent residents, and that is the question of how long you can remain outside the United States without it affecting your green card. The general rule is that if you are absent from the United States for more than 6 months, your re-entry may be questioned. If you are absent for 1 year or more, you are generally considered to have abandoned your permanent resident status unless you obtained a re-entry permit before you left. A re-entry permit can cover absences of up to 2 years. This rule has not changed, but enforcement of it has become significantly stricter. Green card holders who are returning after long absences, even those with legitimate reasons such as family emergencies or medical situations, should be prepared to document the reasons for their extended stay abroad and, where possible, to demonstrate that they maintain ties to the United States during that time. Now we want to address something that is extremely important and that does not get discussed enough, and that is the relationship between green card status and the public charge rule. The public charge rule in U.S. immigration law refers to a legal concept that evaluates whether an immigrant is likely to become primarily dependent on the government for subsistence. For green card holders, this rule is most relevant at the time of adjustment of status, meaning when someone applies for a green card. However, in the current enforcement climate, public charge considerations have become part of a broader conversation about the conditions under which permanent residents maintain their status. While existing green card holders are not routinely subject to public charge review, there are specific circumstances, including certain applications for extension of stay, re-entry after abroad, and naturalization processes, where financial history and public benefit use can become factors that immigration officers examine more closely. We want to be very clear here. Using public benefits that you are legally entitled to does not automatically jeopardize your green card. But understanding the nuances of how public charge policy has evolved and how it interacts with your specific immigration history is something every green card holder should be aware of, particularly those who are planning to apply for citizenship in the near future. And that brings us to naturalization, the process of becoming a US citizen, which is now more important for many permanent residents than ever before. The simplest and most legally secure position a permanent resident can be in is to apply for naturalization as soon as they become eligible. US citizenship provides protections that a green card simply does not. A naturalized citizen cannot be deported for most criminal convictions. A naturalized citizen cannot lose their status due to extended absences. A naturalized citizen has the full range of constitutional rights and protections that come with citizenship. For many green card holders who are currently eligible for naturalization but have been delaying the process, whether due to cost, time, uncertainty about the civics test, or simply not prioritizing it, the current environment is a strong signal to move forward. However, naturalization is not without its own considerations under the current climate. USCIS has implemented updated background check procedures that have extended processing times for many naturalization applications. The naturalization interview and civics test remain in place, and the standards for passing the interview have been applied with increased thoroughness in some field offices. Additionally, any criminal history, even history that did not prevent you from receiving your green card, can create complications during the naturalization process. This is why proper preparation and, in some cases, legal guidance before filing your N400 application is strongly advisable. Now let us talk about something that is affecting a large number of green card holders right now, and that is the intersection of immigration enforcement and workplaces. ICE, Immigration and Customs Enforcement, has significantly increased worksite enforcement operations in recent months. While these operations are primarily aimed at identifying undocumented workers, The reality is that worksite raids and employer audits create environments where all workers, including green card holders, may be asked to present documentation. Every green card holder should carry or have immediate access to their valid permanent resident card. If your green card has expired, you should be carrying your I-797 receipt notice showing that your renewal is pending. An expired green card does not mean you have lost your status, but being unable to produce documentation can create unnecessary complications. Keep your documents current, keep copies in a secure location, and know where your immigration documents are at all times. Let us also address the travel ban and visa restriction orders that have been issued under the current administration, because this is another area causing significant concern in immigrant communities. Recent executive orders have imposed travel restrictions on nationals of certain countries. For green card holders who are nationals of affected countries, the situation is nuanced. In general, lawful permanent residents who are nationals of countries listed in travel restriction orders are still able to return to the United States. LPRs have historically been treated differently from visa applicants under such orders. However, the specific language of each executive order matters, and the situation can change. If you are a green card holder and a national of a country currently subject to any travel restriction or executive order, you should verify current guidance from USCIS, the State Department, and if possible, consult with an immigration attorney before undertaking any international travel. We also want to speak directly to something that many of you may be feeling right now, and that is a sense of fear, uncertainty, or vulnerability about your future in the United States. These feelings are completely understandable. Immigration law is complex, policy changes happen quickly, and the consequences of misunderstanding the rules can be severe. But we want to remind you of something important. Knowledge is your most reliable protection. Understanding the law, understanding your rights, staying current with policy changes, and making well-informed decisions, these are the tools that give you the best possible position regardless of what policies are in effect. You have worked hard to build your life here. You went through a legal process to earn your permanent resident status, and while the environment around you may be changing, the foundation of your status is built on legal documentation, legal history, and legal rights. Protecting that foundation means staying informed, staying prepared, and when necessary, seeking qualified legal guidance. Before we close, we want to summarize the key points from today's video so you have a clear picture of what to take away. Green card holders are now subject to increased scrutiny under updated enforcement priorities, particularly those with any criminal history, even minor or old convictions. Green card holders returning from international travel may face additional questioning at ports of entry and should be prepared with proper documentation and an understanding of their rights. Extended absences from the United States, particularly those over 6 months, can trigger questions about abandonment of permanent resident status, and a re-entry permit is essential for longer absences. Naturalization remains the strongest legal protection available to eligible permanent residents, and those who qualify should seriously consider filing without further delay. Worksite enforcement has increased, and every green card holder should maintain current, accessible immigration documentation at all times. And finally, travel restrictions affecting nationals of certain countries require careful review before any international travel is undertaken. If you found this information helpful and you want to stay current with the latest US immigration news, visa updates, and USCIS policy changes, please subscribe to Global Immigration News right now. We publish regular updates specifically designed to help immigrants, families, and professionals navigate the US immigration system with clarity and confidence. Hit the subscribe button and turn on your notifications so you never miss a critical immigration update. We also invite you to join our WhatsApp channel, where we share quick immigration alerts, policy updates, and important notices between videos. The link to our WhatsApp channel is in the description below. It is completely free, and it keeps you connected to the latest information when you need it most. Thank you for watching Global Immigration News. Stay informed, stay prepared, and we will see you in the next update.